and start with the introduction. Every legal system is tested not merely by rights it creates, but by the forum that educates them. Before an arbitral tribunal decides a dispute, a fundamental question arises. Who decides whether arbitration should proceed? This lies in the heart of Section 8 and Section 16 of Arbitration and Conciliation Act. One calls for judicial restraint, the other recognizes arbitral tribunal autonomy. Together, they reflect a foundational principle of modern arbitration, that courts are arbitral tribunal and partners of administration of justice, each respecting the limits of its own jurisdiction. To guide us through this important conversation, we are fortunate to have two of the respected legal minds. It is my honor to invite to the chair this session, Honorable Justice Somasekhar Sundaresan. There are judges who decide disputes. There are judges who quietly influence the evolution of commercial jurisprudence. Our chair belongs to the later tradition. Honorable Justice Somasekhar Sundaresan is a judge at Bombay High Court, elevated in 2023 and appointed as a permanent judge in 2025. Before joining the bench, he had nearly 25 years of distinguished practice in financial sector regulation, company laws, security laws, competition laws, commercial litigations, appearing before Supreme Court, High Court, and specialized tribunals. Before his elevation to the bench, his lordship built an exceptional reputation as one of India's foremost commercial lawyers, advising and appearing in the matters involving securities, regulations, corporate governance, insolvency, financial markets, and arbitration. Trust me, the list is too long for me to speak. That rare experience of understanding both the courtroom and marketplace continues to enrich his lordship's judicial approach. May I request Honorable Justice Shri Somasekhar Sundaresan to kindly take the chair. It gives me immense pleasure to introduce our speaker, Mr. Vineet Naik, a leading senior advocate practicing before Supreme Court and Bombay High Court and several other high courts. Designated as senior advocate in 2012, he has over 3 decades of distinguished experience in civil and commercial laws, with particular expertise in commercial disputes, domestic and international arbitration, real, etc. Please join me in extending a warm and respectful welcome to Shri Vineet Naik, the senior advocate. With the chair now constituted and our distinguished speaker before us, the court of ideas may now assemble. May I request Honorable Justice Somasekhar Sundaresan to kindly commence today's proceeding and thereafter invite Shri Vineet Naik to deliver his address. The floor is yours, my lords.
Good afternoon. Am I audible? Thanks to Avi for organizing this intensive workshop. I think it's a pleasure to come here, but I think it's very important to organize events like this, which are current and practical for the bar. And speaking for all my colleagues at the bench also, we will remain available to participate in such conversations so that the engagement between the bar and the bench, which is otherwise also a very formalistic one, gets a qualitative upgrade by engaging on issues like we get to engage in today. We sat through in the earlier session for a bit to get a sense of the house and where things are in the conversation in the room. And we'll try and move into our topic with the same perspective and talk a bit about where does this scope of Section 8 reside. Essentially, if you look at the legislative policy underlying Section 8, the idea is to ensure that when parties agree upon an arbitration agreement, they actually adhere to it. 8 and 11 in that sense are two sides of the same coin, but 8 tends to get a little different attention because under Section 8, if despite being party to an arbitration agreement, one of the parties approaches another forum saying, this is the forum in which I seek to enforce my rights, the provision enables the other party to the arbitration agreement to tell that forum, look, stop right there, don't proceed further. We actually had agreed to resolve our disputes through arbitration we have an arbitration agreement. That is the forum in which our disputes need to be resolved. That, in a nutshell, is the heart of Section 8. Now, Section 8 has had a bit of the cliched word that we all use, a checkered history, that courts have tended to vary in their approach as to how deeply they get involved when examining whether or not to refer parties to arbitration. A significant set of amendments took place in 2015, dealing with some of the practices that had been noticed in society of defeating arbitration agreements. And in fact, if you read the provision, it basically says, notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration. That element of that provision was essentially to overcome a wealth of case law on how deeply the courts can wade in when faced with a Section 8 application. When can a Section 8 application be filed? Before whom can it be filed? The judicial authority before which an action is brought in a matter that is subject of an arbitration agreement. So when somebody has approached a civil court or another forum, we often get conflicts between those who adjudicate special legislations like airports authority or public premises. There is an eviction proceeding underway. There is also tension that emerges not just between civil courts and arbitral tribunals, also between specialized legislatively created forums and arbitration. So say there is a lease agreement between say airport, for want of a better example, and a person who has taken a land, a lessee from the airport. That lease agreement has an arbitration clause. The question becomes, would disputes between them be covered by the arbitration clause in the lease agreement, or would elements of eviction from public premises be out of arbitration with all other parts of disputes being in the arbitration agreement, with a statutorily carved out specialized forum being meant to deal with the statutory activity in this example that I gave, eviction. So these are issues that courts will often come up with. So while examining a Section 8 application, one of the elements to bear in mind would be to see, the key element to be bear in mind rather, would be to see if there exists an arbitration agreement. Two, what is subject matter of that arbitration? Is that subject matter overlap between the forum visited with an existing proceeding and the subject matter of the arbitration agreement, had that arbitration agreement actually been invoked? And if there is commonality, if it's the same subject, the court must, it shall, notwithstanding any judgment of a Supreme Court or other court, refer the parties to arbitration. I will refrain from giving examples and live examples, particularly because we as judges have our own constraints on how much we can speak, even in a safe forum like here. But I'll leave case law discussions to Mr. Naik, who's fully equipped, and we've had some conversations of how to conduct this session. But really speaking, if you look at old case law like Sukanya holdings, where the principle of the inability to fragment what is covered in a suit was dealt with, that too often gets cited, even today, despite our being a decade after the 2015 amendments. And very often, those who presented it may not have been aware of why the 2015 amendments came through, which are those judgments that predate. So when research is done as a practical measure, I'm suggesting to all of you, when you research or somebody gives you a judgment as a relevant judgment, check the vintage of that judgment and check whether that has been overcome legislatively by a change in legislative policy. So very often Sukanya holdings get cited as an example of saying you can never fragment the cause that has been pursued in the suit. Fragmentation is not permissible, and therefore don't refer. Now, is it fragmentation? Was it a cause of action that is actually not being fragmented, but appendages having been falsely added to a cause of action which need not have been added? So for example, you go to a district court, you have a dispute over a bipartite MOU, but then you say, oh, but my land in question in that MOU is in a municipal body's jurisdiction. I want to make the municipal authority is a party to the suit. So you say now those parties are not subject to arbitration, therefore this suit can't be referred because as dominus litis, I am entitled to formulate my attack the way I want. I have chosen the municipal party or the MIDC or the SIDCO or whichever be the authority as one of the parties to the suit. So now you can't fragment. This question comes up very often. We have to grapple with it and deal with it. Then again, you have to look at the substance of the suit. And if you look at the substance of the dispute and you find that just clever drafting or just having appendages of parties just to ensure that a larger edifice is created to then say now you can't fragment it is something that the court would go into when faced with a Section 8. We at the High Court tend to get those Section 8s more often after the civil courts have looked at it in a challenge under 37. Of course, on the original side, when a suit is filed, there could be a Section 8 as well. But really speaking, in the heart of this provision, one must remember, lies the need to honor the contractual commitment to go to arbitration. If you decided to go to arbitration, that's a contract that needs to be enforced. When you agreed to arbitrate, that is the only forum as far as practicable. What is non-arbitrable falls in what I would say is judge-made law, law developing over time about the in rem and the in personam distinction. There are also problematic developments in the system. For example, in the securities market, there is a circular saying all disputes in the capital markets will go to dispute resolution through arbitration. Now that can include class action suits. I mean, shareholders coming together and saying the company did not disclose its information accurately. Now is this arbitrable? Would this be an in rem cause of action or in personam cause of action? These are questions that will arise. So when precisely a dispute is not arbitrable is the next question that emerges. Now that takes us to Section 16. When you look at Section 16, again a specific deep inroad in the legislative policy is that the forum that is most equipped to decide arbitrability and jurisdiction is the arbitral forum itself. So we as judges very often have to resist the temptation. Sometimes you can say, oh, but if it's evident to you it's not arbitrable, why would you allow it to go to arbitration and make them incur costs, and this is not friendly? The flip side is, if we believe we are best equipped to take that decision and parties engage and take adjournments and say, let me look up this point more, I had not thought about it, you list it for another week, that week it doesn't reach, then it gets mentioned again, you list it the third week, it reaches, and then again is parted and goes on. That's also costly, that's also expensive. On the other hand, you refer it, leaving the right to agitate under Section 16 open, or if you feel very strongly, directing that the tribunal must consider 16 at the threshold. Though ideally, in my personal view, courts should not dictate to an arbitrator how to sequence the proceedings. But if it looks very strong that the non-arbitrability element looks prima facie a very important point, it is open to courts to say that we request the arbitral tribunal to consider the 16 jurisdictional challenge up front. So therefore, 16 segues into Section 8. And under 16, if the 8th court essentially says, go to arbitration because you have an arbitration agreement, and let the arbitral tribunal decide all facets of arbitrability or non-arbitrability, then arbitration will run its course. If it truly is permitted to run its course, and this is a manner in which all stakeholders, including the bar and the bench, are deferential to the legislative policy of the Arbitration Act, we will not have a situation where the state agencies, as the market player, would have second thoughts about whether arbitration is efficient enough. When we hear about state policy moving away from arbitration, it's also a function of the state's experience with arbitration. The state's experience with arbitration is also influenced by statutory arbitration agreements like the NHAI situation or the railway situation, where there's a statutory arbitration agreement. And who's the arbitrator? Your divisional commissioner and your state machinery, who have 20 things to do, issuing liquor licenses, or maybe not liquor licenses, but 20 other licenses. And I had a case where the poor chap actually filed a letter saying, this is my job description. Now tell me, in this job description, when will I arbitrate? 2030 NHI arbitration. So he said, I can't. So I took a view that he is unable to do it without undue delay, and therefore substituted the arbitrator. So the law will develop and it will come over time. But if courts also start deciding when an arbitrator, despite an agreement, should be allowed in or not be allowed in my respectful view, and we can only speak through our judgments, and I walk the talk in my judgments, the approach has been as far as possible, as far as legally correct, ensure that the arbitration agreement is enforced. Enforce the agreement by ensuring that the subject matter is common, there exists an agreement, send the parties to arbitration. Even weighty questions of jurisdiction, we lawyers can always find weighty questions in the lightest of situations. If weighty questions of jurisdiction are presented, leave it to section 16, the jurisdiction of section 16, because the tribunal is competent enough to answer that question. I think with that prefatory opening, I'll stop here. I'll hand it over to Mr. Naik to take it forward from here. I just need one permission from you all to be excused. I have a flight at 3. So I'll be here till 1 o'clock, and then I'll leave because I do know there's the next session as well. So over to you. Yeah, whatever's coming.
Naik, may I request you to take the podium?
Thank you, Justice Sundaresan. And yes, we are aware of your time constraints, and thank you for really making it today and giving a nice prefatory perspective on a rather complex topic within the subject of the Arbitration and Conciliation Act. Before I get into my I will not say paper, but before I get into my address to all my colleagues here, let me begin by thanking the Advocates Association of Western India for having invited me. Frankly, it's not an invitation. I'm a member of the bar. It's like a homecoming. You have every right to call upon me anytime that you need my help or my services. So thank you, all the office bearers, and my dear friend Prashant Relekar, who's the president. Sorry. Okay. Which? No, I'm okay with this. Is this audible? Am I audible here?
Yes.
Oh, okay, sorry. Okay. Yes, and so now to all the dignitaries here, Justice Kulkarni was here, so also to him as well. We have got this topic of Section 8 and Section 16. So a bit about it. I'm sure all of you have seen the provision, so I'm not going to go on to reciting or narrating the particular provision. But suffice it to say that the basic theme or the underlining theme is that if it's a Section 8 inquiry, then it is obviously at a stage before a judicial forum where one of the parties who's presumably going to be a claimant says that, look, this matter has to go to arbitration and the court should not decide this particular controversy. So that's the limit of Section 8. Section 16, on the other hand, is where the arbitral tribunal itself rules on its jurisdiction. So there is a marked distinction in the qualitative inquiry that goes on in a Section 8 and in a Section 16. Section 8 is therefore primarily a prima facie examination by the court when a party who is signatory to an arbitration agreement says that, look, there is a valid arbitration agreement in existence and therefore the parties have decided to arbitrate. Please do not enter upon this suit and don't get into any detailed investigation and refer the parties to an arbitration. In other words, the scope of judicial inquiry in a Section 8 is only limited to prima facie existence of a valid arbitration agreement. That's the scope of 8. 16, on the other hand, is you are already before the arbitral tribunal. Therefore, the arbitral tribunal will now decide and pronounce upon its jurisdiction, and the inquiry to that extent would have to be far more detailed. the inquiry at that time will have to be far more detailed in a section 16 proceeding. Now, there is a bit of a judicial history to this, and I think I must touch upon it so that you will appreciate how the law has developed and how it has evolved to the position that we are in today, and also how the amendments to the 2015 amendments to the Act brought about a sea change in the approach. Prior to 1996, the Arbitration Act of 1940, if you look at that particular section and you look at today's section 8, you will find that there is a vast difference. In the 1940 regime, courts routinely examined several issues while deciding whether to refer a matter to arbitration or not. They examined the validity of an agreement. They defined whether a dispute existed or not. They also defined jurisdiction, and they also decided whether the claim was live or a dead claim. In other words, the scope of judicial inquiry at a Section 8 stage was pretty large. Fortunately for us, we adopted the unicitral model in the 1996 amendment, and that to a large extent changed the approach in India. The approach thereafter became divided into two stages. Stage 1 is where the court would apply its mind to merely examine whether a prima facie valid agreement, namely an agreement to arbitration, exists or it does not exist. And stage 2 is where the arbitral tribunal will decide all the other issues. Section 8, therefore, is a point of referral. Section 16, on the other hand, is a determination of jurisdiction. So I hope I'm making myself clear, because that is really the nuance, or that's the fine distinction. So Justice Sundaresan just said that the approach of a court in a Section 8 should in that sense be to make a modicum of inquiry only to see if there is an agreement. Have the parties signed the agreement? Are the people who have come to the court already signatories to that agreement? If that is so, then why are you in the court? That is the inquiry under 8. Section 16, on the other hand, is determining all the other issues, where a respondent in an arbitration may say that, look, you don't have the jurisdiction to decide this. Why? Because it's barred by limitation. 2, why? Because, well, we are not signatories to this agreement. How can you involve us in this arbitration? 3, well, this is not the subject matter of the arbitration agreement. How can you conflate two issues and make it a part of an arbitration which is really not maintainable? The dispute itself is not arbitrable. For example, a landlord-tenant dispute, which is squarely governed by the provisions of the Rent Act in a jurisdiction like Bombay, would then have to be argued before a court of competent jurisdiction, which is the small causes court, and that dispute is not arbitrable. So all of these will be determined by the arbitrator at great length, and that determination will ultimately be subject of a challenge under Section 34 substantively when you're challenging an award. So that is really the difference. So when we look at Section 8 and Section 16, if I have to just give a brief point-wise differentiation between the two jurisdictions, Section 8 is the court's power. Section 16 is the tribunal's power. Section 8 is preliminary and a prima facie inquiry. Section 16 is a further detailed jurisdictional inquiry. Section 8 is a referral, whereas Section 16 is a determination by the arbitral tribunal. Section 8, because of all of these reasons, is only a prima facie inquiry, whereas Section 16 on jurisdiction is a final determination. And the most important, Section 8 is pre-arbitration, and Section 16 is during the arbitration. Now, this change or this evolution of law in 8 and 16 had to go through a lot of judicial process. The earlier view, way back in the 7 judges bench judgment of SBP Patel Engineering, where the Supreme Court, while of course considering the aspect of Section 11, held that while appointing an arbitrator, courts could examine also other jurisdictional issues. Although this was in the context of a Section 11 inquiry, because of these observations, naturally, when a matter came up before a court where a defendant raised an issue of referring the matter to an arbitration under Section 8, the court then started examining Section 8 in greater detail. Now, mind you, this is a judgment of 2005. So this was the 1996 regime, and it was a constitutional bench judgment. So naturally, post that, you will find there is a lot of law where detailed analysis of all aspects of jurisdiction are gone into only to decide whether the matter should be referred to an arbitration or not. Mind you, well, the arbitration has still not started. We are only arguing, and all of us, I mean, if we get a brief, as you all know, we are all guilty to that extent. If we get a brief, we have to do our best. So we'll go on arguing till the cows come home. And it is here where the courts will have to step in and will have to see that, in a sense, if there is a commercial agreement between two commercial parties, that this dispute has to be referred to arbitration, then it so must be referred. But Preeti, you want to do that? Yeah, you can do it. I'll just pause here for a minute because you have to leave, so they want to felicitate you.
You keep going.
Sir, I think, may I just request you to take the chair? Let me felicitate you with the chair, and then maybe we'll just take the session ahead.
He has to leave, I'm okay.
You know, when it's Justice Sundaresan, I think we always are away from the traditional norms, and therefore we'll just, in this session, also take a different view, a different approach, actually. May I just request our committee members?
I take it as
So may I just request the office bearers now to please come forward and felicitate the chair and the co-speaker. May I request Shri Prashant Relekar, sir, to come forward, along with Mr. Sukumar Ghanwat, to felicitate the Lordships Justice Sundaresan and Mr. Vineet Naik. Relekar, sir, may I please, Mr. Ghanwat, may I please request you to come first and felicitate the chair. Volunteers, please. May I have a big round of applause? I think we all waited for this session a lot. May I request the bouquet, please? Lordship, this reminds us of that desert which, you know, just always gets over very quickly. And we will definitely miss you, sir. Thank you so much for gracing the occasion. It's such short notice. May I request Relekar, sir, to please felicitate Vineet Naik, sir.
Thank you.
Everybody up there, please, round of applause.
Thank you so much.
Thank you so much.
Thank you, Prashant.
Vineet Naik, sir, thank you so much. From entire team, Avi. Friends, we're going to have a question-answer session, just that Justice Sundaresan will not be there to answer those. So anybody who has any questions specifically for him can write it down to us. We'll send it to his chamber. He specifically asked us, please not drag me into this. Thank you so much, sir. May I just request the volunteers to please help Justice Sundaresan to the chair. Vineet Naik, sir, may I please request you to take over?
So since Vineet has been interrupted already, I'll just say...
Yeah, sure.
Oh, thank you so much.
I'll take a minute and leave. Thank you very much. In most seminars, we end up having a time overrun, and some session has to compensate and cross-subsidize the time, and it's been ours. But we had a discussion even beforehand, so I'm sure he has a wealth of information to share. So please direct all the questions you had for me to Vineet, and I have no doubt he will deal with it. All right, thank you so much.
So no questions going to his chamber. That's an indication.
Hello.
Thank you.
Thank you so much, sir.
See you. Thank
You'll
you.
reach any.
Thank
So
you.
actually we had decided to make it an informal dialogue between the two of us, but then we thought it will be too late to change the flow of the format. Sorry, again, I have two mics. Anyway, so I was on the judgment of the Constitution bench in SBB Patel Engineering, where in a section 11, the Supreme Court said that these are all other aspects that you need to examine, which is why courts then started examining all of these different aspects. Then, fortunately, in 2009, there was a slight departure, and that was the judgment in National Insurance versus Bograph Polyfab. It was a judgment where the court classified as to what are the issues that must be decided, what are the issues that may be decided, and what are the issues that should not be decided. So, first, as regards what it must decide, one, whether there is an agreement. If there is an agreement, are the parties before it the parties to that particular agreement? Then, these are aspects, and whether the party has approached the right High Court. These are the issues which the court must decide. As regards the issues which court may decide, the Supreme Court said that issues of limitation, issues of accord and satisfaction, that the Section 11 court may decide either to pronounce on it or leave it to the judgment of the tribunal. Then the issues which should be decided is whether the claim falls, that is should be decided by the tribunal, is whether the claim falls within the... Sorry.
Can we just stop that and you can use this?
Okay.
Just use this, put that on.
So whether the claim falls within the arbitration clause and the merits of the claim. So these two aspects you are not supposed to decide. So then there was a departure post SBP and Patel Engineering. Then came the 2015 amendment. In the 2015 amendment, there was a non-abstentee clause inserted. That non-abstentee clause was notwithstanding any order of the Supreme Court or of any other court. If, unless otherwise you are satisfied that no agreement exists, then stay your hands and let the arbitral tribunal decide on the entire dispute. So that became the 2015 amendment, which was a noticeable change and a progressive legislative change for the simple reason legislature in its wisdom realized that courts were getting clogged with inquiries even before the merits of the matter on the aspect of whether the matter should be referred to arbitration or not. So the 2015 amendment came in. The intention of the legislature therefore was very clear. Courts should stop interfering wherever there are arbitration agreements and let the process of arbitration take place. There is a reason for this. India was into developing rapidly into the international spheres. Our corporate houses were entering into different agreements with various companies, various other entities which were trans-border entities. Arbitration clauses were almost a norm in every commercial contract. But the reputation of our country was somewhere getting a little tarnished because arbitrations were getting delayed, disputes were not being resolved, and commercial disputes were not getting resolved, as a result of which foreign parties were little hesitant to enter into agreements or contracts within the realm of Indian jurisdictions. In fact, therefore, many a times they did provide for arbitration clauses, but of venues and arbitrational provisions governed by other institutional arbitrations outside India, such as an SIAC arbitration, for example, that is the Singapore International Arbitration Center, or ICC, that is International Commercial Arbitration. So these organizations, which were arbitral organizations, were gathering momentum. Now India had to do something. So we had to keep up pace to see that all of these foreign parties are not dissuaded from entering into transactions with Indian parties. So the 2015 amendment came. In a judgment of 2017, that is Felgura versus Gangavaram Port Limited, Justice Nariman observed that at a referral stage, the court only sees whether an arbitration agreement exists, nothing more. So now this is 2017. Now the reason I'm giving you this is because now you will see the flow of the law. 2015 the amendment came, Justice Nariman's judgment in Gangavaram in 2017. Then came 2019 in Mayawati trading. The Supreme Court emphatically held that after the 2015 amendment, the court's examination is only to be confined to the existence of an arbitration agreement. All other issues should be left to the discretion and wisdom of the arbitral tribunal. Then in 2021 is the important judgment in Vidya Drolia's case, where Justice Ramanna, along with the brother judges of the Supreme Court, explained that the court performs only a prima facie inquiry and not a full review. The court should interfere only when arbitration agreement is manifestly non-existent or ex facie invalid. Everything else, including fraud, limitation, novation, accord, and satisfaction, and even jurisdiction, should ordinarily go before the arbitral tribunal. So now you are seeing the trend from the 2015 amendment. There's a 2017 judgment, 2019 judgment, 2020-21 judgment, and this is how the law starts evolving. The court, in all of these judicial pronouncements, coined an expression that when in doubt, refer. In other words, if somebody is trying to obfuscate the issue on the point of reference in an 8 inquiry, and if you are convinced that prima facie there is a valid agreement, stay your hands off the matter and refer everything to the arbitration. Let the arbitral tribunal decide. So this was a much needed approach, and it was a welcome approach. Now, as I indicated at the beginning, that there is a difference between a referral jurisdiction and a difference between a tribunal determining its competence to decide on a particular arbitral dispute that is referred to it. Before the arbitration or the arbitral tribunals also, there is a lot of law. And since everything cannot be explained in a short span of time, I'm sure most of you all who are familiar with this particular branch of law would recall that there was some, if I may use the word, some tension between the provisions of the Stamp Act and the provisions of the Arbitration and Conciliation Act. Now it all started with the controversy as to whether an agreement which is not validly stamped or is improperly stamped, whether you can at all refer to that particular agreement because that agreement has an arbitration clause, and refer the parties to an arbitration because it is not stamped. So how can you receive it in evidence? You cannot look at it at all. So this was a conundrum. This resulted in a lot of litigation. One of the earlier judgments was in 2011 of the Supreme Court, which is the SMST Estates judgment. The issue was again regarding the stamping of the document. The court held that before referring parties to an arbitration, the judicial authority must first determine whether the instrument was duly stamped and thus would otherwise postpone the arbitration. In other words, the courts now started getting stuck in determining whether the agreement is stamped or not stamped or not stamped. So first was SMS, then came Garware wall ropes. They said that no, you must first look at the document. If it is not stamped, you can't refer it to arbitration. This was given a departure in the judgment of NN Global, which was a 3-bench judgment. That was a judgment by Justice Chandrachud, Justice Indu Malhotra, and Justice Indira Banerjee. They said no, you can separate the clause. And as to the issue of whether it should be stamped or not, is something that the tribunal can decide. But for the purposes of reference, it's good enough if there is an agreement. So they upheld the fact that arbitration has to be expedited. Courts cannot get into detailed investigation. Unfortunately, though, at that time, another coordinate bench had accepted the view of Garware wall ropes. As a result of which, Justice Chandrachud's bench, while deciding NN Global, made a reference to the constitutional bench because there was a conflict between the other judgment which approved, because that was also a coordinate bench of 3 judges, which approved the judgment of Garware, and this NN Global which was taking a different view. So it went to the Constitutional Court. Constitutional Court unfortunately took a view diametrically opposite to NN Global and came back to the stage of SMST and Garware and said that an unstamped instrument is not enforceable in law, consequently you cannot look at it, and therefore the court must first decide whether it is properly stamped or not before it referring to an arbitration. This ultimately resulted in a curative petition which was decided by 7 judges, and fortunately we went back to the NN Global law which was authoritatively pronounced by Justice Chandrachud, Justice Malhotra and Justice Banerjee, that you will not get detained because of the stamping aspect. Now the reason, I'm just explaining this to you all, is to show how the law keeps changing, how it evolved. And the entire emphasis or focus appears to be that promote arbitration. If there is an arbitration, especially commercial matters, courts should not clog themselves with these kind of litigations. Parties have already agreed to go in for arbitrations. Allow them to go and settle their disputes. So that was a welcome approach which came by virtue of this interplay judgment. In fact, in one of the recent judgments of Justice Sundaresan, I had the occasion of appearing, and he went to the extent of saying that sometimes clever drafting is also to be looked at, because you deliberately draft a petition or a suit in such a manner, make some parties against whom you are seeking practically no relief, but just make them as pro forma parties and say that they are not signatories to an agreement, so how can we refer them to arbitration? So Justice Sundaresan's judgment in Villa Real Con says that you have to be mindful of this type of clever drafting and be conscious that because of this, arbitration is not frustrated. Fortunately for us, with this kind of change of law, or rather evolution of law, we are now in sync with the international law, so much so that it is now the same principle under Section 30 of the English Arbitration Act, Article 1465 of the French Code of Civil Procedure, as also Section 3 of the Singapore International Arbitration Act. So India is now in sync with a lot of these international and foreign jurisdictions, wherein the emphasis is towards arbitration. So in conclusion, because we are running short on time because the other session also spilled over. In conclusion, Section 8 and Section 16, as you have seen, are totally different. They operate in different spheres. While 8 is a prima facie inquiry, Section 16 is really a further detailed inquiry on the jurisdiction. The idea and approach of the courts is always to see that if there is a valid agreement, don't waste time in the courts. Go by way of your alternative dispute resolution and try and resolve the disputes. So I hope in this short time I have been able to, sort of convey to you all what are the nuances or what is the interplay between Section 8 and 16. Should you have any questions, I don't know, do we have time? Yeah. So if you have any questions, please fire along and I will try my best to answer them in the best possible manner.
Hello. Sir, in the balcony. Yes. Good
afternoon. Is there a dress circle as well?
So, good afternoon to you and everyone, all the learned dignitaries. My question actually is in your capacity as the authorized answer giver for Justice Sundaresan, because it's regarding Section 8. Sir, there's a condition under Section 8 regarding a requirement that you have to put in an objection of the existence of an arbitration agreement before placing on record your first statement. That is a requirement. So my question is that isn't that defeating the whole purpose of the pro-arbitration approach? And what is your opinion about permitting a party to raise the objection of the existence of an arbitration agreement even after they put in their first statement in the civil court?
See, I think, it's a very valid question that you have raised, but I think that is more directory than mandatory. Because a party, a person coming to the court would have already filed a plaint. The plaint would have certain documents. One of them would be the particular agreement on the basis of which you are saying, I have terminated the agreement, or there is a breach of that particular agreement. So, it's only prudent that the defendant in that particular suit or the party respondent raises the objection at the first opportune time so that judicial time is not wasted. But I would not consider it to be a mandatory provision, in other words, that you miss the bus, number one. However, the position may be slightly different if you permit the trial to start. Because then, suppose issues are framed, you filed your written statement, and one of the issues is whether this suit is whether this court has jurisdiction or not. That it may be a little too late, because then that is defeating the purpose of a Section 8 reference. Yeah. Section 8 is a referral power, that's what I say. So that will be defeating the purpose.
Thank you, sir.
Vineet sir, I have the question regarding the Section 8 and 16. Generally, the lease agreement or the leave and license agreement where the arbitration clause is there, when the issues come before the court, due to arbitration clause, matter refers to an arbitrator. Before going before the arbitrator, generally found the issue is of the particular statute which was dealt by the authorities or the court. So arbitrator again reject the issue and direct to go before the particular court or the authority. What is the actual, when this, in such a manner agreement, what should be appropriate remedies for a person, whether to go before the arbitrator or the authorities directly? That is the first question. Second question in respect of the same, that in what manner the arbitration clause should be added into an agreement so that it should not be an ambiguity for the court or the particular authority to deal in such situations, where the particular law is provided the remedy, like for leave and license agreement, whether it's a commercial or the residential, the eviction authority under the Rent Act or the small cause court have the jurisdiction, or the another incidents which generally come across where the society member and the developer during the redevelopment agreement, they have the agreement clause, arbitration clause in the agreement, but the member and the society during the process of redevelopment have some issues. So which is the appropriate forum for such, and how that clause should be treated in the agreement?
So thank you for your query. Actually, it's a very practical and a very important query, because we come across this on a regular basis. Now, in fact, you actually answered the query yourself. So as you know, this dispute between licensor and licensees and landlord and tenant, that has been squarely answered in the judgment of Justice of Vidya Drolia. So in whichever jurisdictions there are special provisions or special acts by virtue of which these disputes are exclusively to be decided by, in our case, let's talk about our jurisdiction, landlord, licensor, licensee, landlord, tenant, exclusively small causes court, be it under the provisions of the Rent Control Act or under the Presidency Small Causes Court Act, which is our 41. Their exclusive domain. So there is some distinction or bifurcation now which is sought to be made, that as regards the quantum of amounts, etc., to be paid, that can be referred to an arbitration. But as to whether the person should be evicted or not is squarely within that jurisdictional domain, therefore the arbitration cannot go on. That is one. The other aspect is that, which you asked, is very important, because this is on a daily basis, that there's a mass redevelopment going on in this city. Most of the developers enter into contracts with the society. Now, if there is an arbitration clause, according to me, it would have to be referred to an arbitration. Because there again, there is some sort of dichotomy in law, whether a simpliciter suit will be maintainable in a civil court, or because these are cooperative societies, it would be maintainable under a dispute under Section 91 before the cooperative court. I think there is a series of judgments of the Bombay High Court which take a view that it is not a business of the society to redevelop a building. So if it is not a business of the society, then under 91, you need not go. But there is one judgment of the learned single judge which has taken a different view, where it said that if it is ultimately claiming through the society, then 91 is purely maintainable. But the facts in that case were slightly different because the decisions were being taken by the administrator of a society. And thirdly, and most importantly, the drafting of an arbitration clause should be very crisp, precise and unambiguous. It should be clear what is it that you seek to refer, how many arbitrators, what is the tribunal that you wish to this thing, and also the venue. So there should not be any scope for interpretation or ambiguity. So that's how I would answer those three questions. Thank you for your question. It's a very interesting question, actually.
My lord, I'm Advocate Brijesh.
I'm not a...
Yes, maybe in the future. So, sir, my question is... Vineet, sir, my question is...
I think this should be the last because...
Yes. My question is regarding Section 16. See, there are many organizations...
Section, sorry?
16. There are many organizations who are having the unilateral appointment of arbitrators. And then...
I'm sorry, I'm not able to hear you. There's some echo.
There are many organizations who are having unilateral appointment of arbitrators, and they proceed with the arbitrator, even if it is registered, objection is registered that we have not consented you to become an arbitrator. But then again, there is a 16(6) we have to take recourse of, because the award is passed in absentia or without taking objection. There is no safeguard as such in this Section 16 towards this. So any light on this point, sir?
See, you're right. Most of these named arbitrators or institutional arbitrators, I mean, that point is really not open now for debate. Because the Supreme Court has taken the view that merely because an officer of that particular organization has been appointed as an arbitrator, you cannot presume bias. So you'll have to go on with it. But I mean, for the want of my memory, there is a judgment of the Supreme Court where I think Gautam will probably throw some light on it. There is one judgment of the Supreme Court which was about 3 or 4 years ago, where one of the judges have said that a time has now come that there must be a departure and, to have it more transparent and unbiased, because it's not a question of just bias, it's also a question of perceived bias. For example, you're doing an arbitration with, let us say, MSRDC. And that MSRDC managing director is the arbitrator. As a contractor, I don't have that faith in going before that authority. Yes, but unfortunately, there are line of judgments of the Supreme Court which have taken the view that you cannot presume bias. So you'll have to go with that arbitrator.
Correct, but I'm on the
part. There is a change. I think that there should be a legislative change to that provision, if you ask me. Yes. Yes, of course.
12 and 13 deals with it. It is not 16. So about impartiality, independence, that will come under 12 and 13. So 12 is the mechanism. 12(6) is the ineligibility at the threshold. So that is covered under the two schedules, 5th and 7th. Okay. And in 13 you raise the challenge, but similar to 16, the matter goes on even if you fail in the challenge. You can challenge it at 34. The two famous judgments in this are Voice Alpine, and the other one is HRD Marcus. So you'll find that this has been extensively set out in that. Okay.
Thank you, Gautam. Thank you, Gautam. Okay, I think, thank you very much. I'll take your leave. Thank you for patiently listening to me. And I hope I've been able to convey in this short time whatever I could. Thank you. Thank you.
I don't know whether I should thank Vineet sir more or Gautam Mehta sir for also adding to it. Next time I'll see to it, sir, that we have you here. Vineet Naik, sir, yes. My apologies, I missed out on that. Vineet Naik, sir, thank you so much. It was an enlightening session.